Zita, good morning to you. What's your reaction to the signing of this crucial bill, and what does it mean going forward?
Well, the Center for Child Law welcomes the signing of this important bill. What it means going forward is that children younger than 12, if they commit an act that is considered an offence, will not go through the criminal justice system. They won't go through the criminal justice process. They will be referred to probation officers instead. So these are social workers who work around criminal justice issues. And then the social workers or probation officers will assess the children and determine if these children, what sort of support the children need. So does the child need to be referred to a children's court because they are in need of care and protection, or does the child need to be referred to either counseling, therapy, or other supportive services? So this is something that we welcome and applaud.
So the Act also repeals the requirement to prove criminal capacity for the purpose of diversion and preliminary inquiries. How important is that?
Well, that's very important as well. So what this means is that usually when a matter is reported to the police, so now here we're dealing with children who are between the ages of 12 and 14, right? So when a matter is reported to the police, it's saying that a child between the age of 12 and 14 has committed an offense. The police then do an investigation and then send the file over to the prosecutor. At this point, a prosecutor can decide that this child should be diverted, so sent to a program for rehabilitation. Before this amendment, the Act said that the prosecutor has to determine if the child has criminal capacity. At this point, with this amendment, this doesn't have to happen anymore. All the prosecutor needs to determine is if the child will benefit from this diversion, and this is the same thing for the preliminary inquiry. Criminal capacity doesn't have to be proved. The child can be sent to the preliminary inquiry where the magistrate determines the circumstances of the child.
What provisions does the amendment make on the appropriate punishment for various crimes?
Well, so appropriate punishment still remains as is in the Act, and what the Act tells us is that a punishment is based on the child, is based on the circumstances of the child, definitely the crime that the child has committed. Therefore, if a matter has been heard in a child justice court, a child has been convicted of an offense, then the magistrate or the judge hearing the matter will determine the punishment based on the individual facts in front of him or her.
In some instances, you have young children being used by older children or adults to commit crime. How will that be dealt with?
Well, what usually happens here is that, let's say a child is used by an adult to commit an offense. Then here, a child justice court, let's say the matter goes to the child justice court, the magistrate will look at the individual circumstances. So what happened in the case? How did it come that the child was used? And then determine the best way forward. Sometimes a child may have to be referred to the children's court because a child will be what we call found to be in need of care and protection. So again, individual circumstances will determine what should happen to the child and what sort of support services that child should receive. At the end of the day, it's all about ensuring that a child receives rehabilitation and receives the sort of support that they need in order to not commit any offenses or any crimes.
And this amendment arises from a recommendation in the report on the review of the minimum wage of criminal capacity. What necessitated that report?
Well, when you look at the Child Justice Act, the Child Justice Act says that every 5 years there must be an investigation into the minimum age of criminal capacity. So one needs to look at how many children are committing crimes and what age ranges are those children in, and what is causing children to commit crimes. So at this point, an investigation was done, and it was found that children who are younger than the age of 12 years old don't need to be exposed to the criminal justice system. Then children in that age group are not committing as many crimes, and they need some other sort of support services instead of referred to the criminal justice system.
All right. Look, thank you so much for your time this morning and giving us reaction to that amendment to the Child Justice Amendment Bill.